Hello everyone, my name is Narayan and I'm currently pursuing BA LLB from University of Petroleum and Energy Study and my fourth year, and today in this video I will be talking about the basics of the concept of culpable homicide and murder. So the provision for culpable homicide is being given in the section 299 of the IPC. What does it say? It says that whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death or with the knowledge that he is likely by such act to cause death commits the offense of culpable homicide. Now, let's take an example. Suppose A lays sticks and turf over a pit with the intention of thereby causing death or with the knowledge that death is likely to be thereby caused. Z, believing the ground to be firm, treads on it, falls in and is killed. So A has committed the offense of culpable homicide. Now, A knows Z to be behind a bush. Now, B does not know it. A, intending to cause or knowing it to be likely to cause Z's death, induces B to fire at the bush. Now, B fires and kills Z. Here, B may be guilty of no offense, but A has committed the offense of culpable homicide. Why? Because he was aware of the fact that Z is there behind the bush. Now, A, by shooting at a bird with intent to kill and steal it, kills B, who is behind a bush. Now, A, not knowing that he was there, here, although A was doing an unlawful act, he was not guilty of culpable homicide, as he did not intend to kill B or to cause death by doing an act that he knew was likely to cause death. Now, a person who causes bodily injury to another who is laboring under a disorder, disease, or bodily infirmity and thereby accelerates the death of that other shall be deemed to have caused his death. Now, where death is caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused the death, although by resorting to proper remedies and skillful treatment, the death might have been prevented. Now, suppose the causing of the death of the child in the mother's womb is not homicide, but it may amount to culpable homicide to cause the death of a living child if any part of that child has been brought forth, though the child may not have breathed or been completely born. Now let's move to the concept of the murder. Section 300 of the IPC talks about murder. It says that except in the cases hereinafter accepted, uh, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death, or if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused, or it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death, or if the person committing the act knows that it is so immensely dangerous that it must in all probability cause death or such bodily injury as is likely to cause death, and commit such act without any excuse or incurring the risk of causing death or such injury as said. Now, suppose A shoots B with the intention of killing him and B dies in consequence. Then A is said to commit the murder. A, knowing that B is laboring under such a disease that a blow is likely to cause his death, strikes him with the intention of causing bodily injury. B dies in consequence of the blow. Now, here also A is guilty of murder, although the blow might not have been sufficient in the ordinary course of nature to cause the death of a person in a sound state of health. But if A, not knowing that B is laboring under any disease, gives him such a blow as would not in the ordinary course of nature kill a person in a sound state of health. Here a, although he may intend to cause bodily injury, is not guilty of murder if he did not intend to cause death or such bodily injury as in the ordinary course of nature would cause death. Let's move to the another illustration. Now suppose A intentionally gives B a sword cut or club wound sufficient to cause the death of a man in the ordinary course of nature. Now, B dies in consequence. Here also A is guilty of murder, although he may not have intended to cause B's death. Now, suppose A, without any excuse, fires a loaded cannon into a crowd of persons and kills one of them. Here also A is guilty of murder. Although he may not have had a premeditated design to kill any particular individual, but as he was firing into a crowd, it was quite logical that somebody might get hurt and might get killed. So therefore, here he will be charged under the offense of murder if any one person dies in that course. Thank you so much.